first slides, but
We'll tell you. Rhino film.
yeah, but importantly, we were talking about two types of information under HIPAA that are important to know about, that will matter for the rest of the presentation, so I want to cover this real quickly for you. So what does HIPAA protect? It's really the protected health information, which is anything that is individually identifiable health information in any form, media, electronic, paper, oral. So the point is that anything that reveals what care you gave to somebody, their medical condition, the fact that you even treated somebody, that you went and gave, Mrs. Smith treatment, the fact that you had a call to her house, that's protected by HIPAA information because it identifies her. De-identified information you're allowed to share, which is anything that does not identify an individual. It's the generic. If you strip out all the identifiers, the person's name, home address, or anything that could be used to figure out who it is. So if you, for example, had to treat a Chicago Bears player in town, and say, it'd be a bad idea to say, oh, I did a call to a Chicago Bears player, because now you've shrunk down the universe of potential patients to a very small number. How many Bears live in the village? If it's 4 or whatever, you've now identified who you treated. Somebody could guess and figure out who it is. So, generic, I treated somebody today for a broken leg, absolutely fine to share. Because there's no information there that could be used to figure out who it is. So, as we talk today through all of our examples and what's going on in the rules, keep this in mind. You can definitely share, but nothing that reveals who the person may be. So, the privacy rule. Now that we know the definition, and it's pretty simple. A covered entity may not use or disclose that personal health information, the PHI, except either as the rule permits, and we're going to talk about that. Those are all the exceptions, and there's a lot of them. So you can share that health information so long as you're within an exception, or as the individual, the patient, who is subject to the information, authorizes us in writing to release. So we were talking about, people asked, well, what happens if we get a FOIA request or a subpoena or whatever it may be? We can give somebody's ambulance reports out, so long as the patient, in writing, tells us it's okay to do so. So they can say, give it to my attorney, give it to my friend, give it to whoever, but we need their authorization. So who can obtain the PHI, that health information? Well, the patient can get their own health information, absolutely fine. They can come in and come up to the front desk and say, hi, I want my ambulance report. Okay, as long as we know who it is, check an ID, they can get it. Or their designated representatives. We can always give a parent their minor's records. They're the ones who have the power of attorney, the custody over the medical care of their child. Whether the child is a baby, whether the child's 17, a parent can get those records.
How do you know that though? I mean, I've had parents come in and say, I'd like...
Hold that thought, because we're going to talk about that later in the presentation, and that's an important issue. But for now, just know that a parent can get it. Identifying if somebody's actually a parent is more difficult. We'll talk about that. The other people, our attorneys, this happens all the time, and probably the one, other than the patient, the one who most often wants information, absolutely fine to give it to the attorney, so long as we have a valid HIPAA release that says it's okay. Or any other person. As I said, it could be their friend, it doesn't matter, so long as we have the valid HIPAA release. So you are not the ones necessarily processing HIPAA releases and looking at the requests, the FOIA requests and subpoenas when they come in. But I do want you to know that while you don't have to memorize this, understand for a HIPAA release to be valid, there are all sorts of rules. A huge checklist of items that have to be in it. It's not enough to write on a piece of paper, please give my ambulance report to my attorney. Does not work. So just to give you a couple of examples of what needs to be in there, an expiration date. It needs to say this HIPAA release is valid until the end of the year, or at the end of my litigation, or whatever it may be, but it has to have an expiration date. It has to have a statement that informs the patient as they're signing it that once the information is released, it may no longer be protected by HIPAA. It may be out there in the world and it's no longer protected. It has to say, it can't just say, I authorize doctors. It has to say, well, the village. It has to be exact on who we can release it to. So the important part that you need to know is if somebody comes to you, go, how do I get, how can you get my ambulance report, or who can you send it to, or whatnot? If they ask you how to get records, tell people. You can submit requests. If you want me to send it to another person, I need a HIPAA release, and make sure it's a valid one. So it's very technical, and I work with Marty on this, and if there's questions about whether there's something that's a valid release, let me know, we can talk about it.
How time sensitive is that if somebody comes in on a Friday and,
So if they submit a FOIA request,
what if they just come to the station looking for the document?
the best thing to do would be give them say you need to fill out a request, a FOIA request.
Okay.
A FOIA request itself can be kind of cocktail napkin. It could be a piece of paper, a post-it, an email. It doesn't have to be on an actual form. It just says, I'd like this record. Now, if it's the patient, we don't need a HIPAA release. If it's somebody other than the patient, we're going to say, thank you for your request. We'll process, to process this, we need a HIPAA release. And then under the Freedom of Information Act, we have 5 business days in which to respond. And if we can have one extension, we can ask for more time and get 5 more business days. So we have time to do it. But it's always, if you know somebody needs something, it's always better for customer service just to say, hey, you want me to send this to somebody else? Get me a HIPAA release.
For the patient though, you're saying I don't need
a release.
FOIA request either?
No, you should. To document it. Technically, if they come in and you want to print out their ambulance report, you check their ID, yep, it's the patient, and you want to go here, and there's no other information in it that would be exempt, you could. It's not illegal. My general advice is if somebody wants the record, is do it as a FOIA request. That way we're documenting and having, who we know who we're giving records to, when we gave them out, so we can always track it. Also, making sure that our FOIA officer is looking at it to make sure there's nothing else in there that, should be removed. So for example, if it's a traffic crash and the patient's there and there might have been 2 patients and the report has a line or 2 about what we did to the other person in the car, well, that patient doesn't get that information. That will have to be redacted. So it's always good to process it as a FOIA request to make sure you're not making a mistake. So, the exceptions to the privacy rule. So we can give it out, the information, if the privacy rule says it's okay, and that's the exceptions. And there's a lot of them. The good news, and this is good for you, is that when they wrote the privacy rule, they recognized that there's a lot of times you have to share information, even when the patient doesn't say yes, or you don't have a HIPAA release. So you do this all the time. You share with others. So the question is, does it fit within one of these exceptions? And if it does, it's okay. So the first is you are allowed to share with other treating medical providers if it's for the treatment payment of the healthcare operation. So what does that mean? Well, you transport somebody to Evanston Hospital and you get there and you get to the emergency room and you say, doctor, I just picked up this person, here you go, I checked their blood pressure and the ambulance, it's, whatever, 80/20, that would be really bad, right? But, or whatever it is, but you share that information with them all the time, right? And you don't have a HIPAA release. It's absolutely okay because you are sharing with somebody who's another treating medical provider. Okay? Now, let's break this down a little further. You're in a restaurant. Somebody goes in a cardiac arrest, and you get there and you're treating the patient, and there's somebody there who's helping, who says, I'm a cardiologist, and they're helping you administer. Can you talk to them about it as you are treating that patient? The answer is yes. They are another treating medical provider who's and they're there to provide treatment. However, here's an example. You go to somebody's house, they're in cardiac arrest. You treat them, and as you're wheeling out the patient, somebody comes over who's the neighbor and says, hi, I'm a doctor, I live next door, I want to make sure Mrs. Jones is okay. Can you tell her? Can you tell that doctor? No, because they're not there to treat the patient, they just want information. They're not a treating medical provider, so you can't share with that person. You can share to obtain payment from insurance companies. So Blue Cross Blue Shield, you know, you transported somebody, we want reimbursement, we can talk to them, not a HIPAA violation. You can share for quality assessments, legal services, audits, performance evaluations. So what that means is, you can call me up on the phone and say, you're the village attorney, this question, you know, we were on a call and this issue came up, what do I do? Not a HIPAA violation, because you're doing it for legal services. Now, the example that I gave earlier, and this is really important. The example I gave earlier of the paramedic who in a training session like this brought up a patient's case and shared that person's information. They weren't sharing to another outside, remember, it wasn't to a third party, it was within the department. So the question is, when can you share within the department? If you just share with each other, you get back from a call and say, hey, you know, just saw Mrs. Jones again, third time this week, you know, or somebody, let's say, you know, somebody, you'll never believe who I treated today. You know, this actress was in town, fell down the stairs, I got to treat her. That's a HIPAA violation, telling each other things. Because it's not for the treatment, the payment, or for the healthcare operation, right? You're just sharing to share. So that's a violation. However, for performance evaluations you can share. So if you come back and you're trying to say, how do we do on that cake, on that run? And the chief sits down with you and says, you know, I just want to talk about this case to make sure that we're doing things properly. What can we do to improve? Absolutely fine to share. So you can share, and I think of it this way: as long as you have a purpose, it's furthering your duties, your obligations. It can't be sharing with each other just because you want to share. It has to have a purpose.
Are you gonna talk about the actual physical piece of paper too, later on, or is this the time to ask?
You can ask.
You finish the ambulance report. When's that paper become a violation, or what do you do with it?
So like for your ambulance report, who can you share with internally?
Well, so you print it off and you put it somewhere.
Okay.
Is there some specific requirements for that document?
Yeah, so the issue is it's whether you're telling somebody orally or it's on a piece of paper, the same rule applies. So you should not be giving it to anybody except if it's for healthcare operations for certain purpose. Like, do you have a purpose with giving it to somebody else in the department? So for example, you need to give it to your superior to read over and make sure that it's accurate. Or again, he wants to assess what happened to make sure that things went fine on the call. Absolutely fine. Absolutely fine. Go ahead and share that. But you're doing it for a reason. It can't be, I did my ambulance report, and then you're just curious and you give it to somebody else. Or you shouldn't be logging onto the system and just pulling up somebody's random report just because. You know, or I want to see if we've ever in this town treated Michael Jordan, so I'm going to go on our system and type in his name and see what pops up. That's a HIPAA violation. So just think before you do anything or share information or ask for information for that matter, make sure that it's for a purpose. And if it's part of your duties, then you're okay. This is another time that we are allowed to share, and this is really important when you're in the field. So I talked about you can share when you have a valid HIPAA release from a patient. The other situation in which you can share patient information with somebody else is when the patient is present and has an opportunity to agree, acquiesce, or object. Now what does that mean? Well, let's say you go to somebody's house because they're having a party and there's a bunch of friends there and they fell and twisted their ankle. So you're there in the room and you're going to provide care, and the person knows that there's all of their friends standing in the room while you're treating. Well, unless they have an opportunity to object and say, no, please, I want my privacy. They have an opportunity to acquiesce. It's, you know, they sit there and they allow you to continue while everybody stands there. Not a violation, because they've had that opportunity to agree, acquiesce, or object. Or you go somewhere and they're with their friend and, you know, is there for comfort, and you say to them, is it okay, you know, is it okay if we talk with your friend here? And they say, yeah, I'm fine with my friend knowing. Then it's absolutely fine. This is the, you know, common sense stuff. You do this all the time when you treat somebody. There might be another party there in the room, and as long as they're not objecting to it. Now, the only rule and caveat is that the person has to be aware. They can't be unconscious, or this rule doesn't work. Or so injured that they may be conscious, but they can't really make a reasoned decision. Does that rule make sense? If the patient is incapacitated, this is another exception, if the patient's incapacitated, it's an emergency, and in the exercise of your professional judgment, it's in the best interest of the patient to share, you can share. So again, you go to that party, the person's down on the floor unconscious, so they can't acquiesce or object. They're unconscious. You don't know if they've been drinking. You don't know if they took pills. You don't know if maybe they just have an underlying medical condition. So you start to talk to people in the room or upstairs and say, hey, has anybody seen this person take any pills? Or do you know if they have medical, their blood pressure is really high. You're sharing it. Blood pressure is really high. Do you know why that would be? Absolutely fine to do that, so long as it's an emergency and within your professional judgment, you think it's in the best interest of the patient. So you can't just share because or after the fact, but during that emergency, it's okay if you're sharing information because you think it's the best thing to do. Incidental disclosure. This is another big one that happens all the time, and you're protected from it, which is good. Is you use as long as you use reasonable safeguards when sharing or when talking or giving and there's an incidental disclosure, you're okay. So again, you're in a restaurant treating somebody for cardiac arrest. You can't sit there in the middle of the restaurant shouting out, hey, when the patient's right, do you have any underlying medical conditions I should know about? I'm now going to take your blood pressure and start shouting where everybody hears it. That's not using reasonable safeguards. But if you're talking in a reasoned voice and somebody 4 tables away happens to overhear the discussion, that's an incidental disclosure, absolutely okay. You're in somebody's house and you don't even know that there's somebody else in the house. They're standing around the corner and they overhear the treatment. Absolutely okay. It's an incidental disclosure and you're taking reasonable precautions. So that's a good protection for you. You're also allowed to share for law enforcement purposes with the police or the medical examiner. Medical examiner, after a call where somebody passed away, needs to interview you to talk about what happened. Absolutely fine to share with them. And it's okay to share with the police as long as they're carrying out their law enforcement duties. So you go to a drunk driving accident and and they need to do an investigation. They're going to come to you and say, well, what did the patient say to you while treating? Did they smell like alcohol? Did you notice anything that's important for our investigation? Absolutely fine to share. Now the caveat on that is it has to be for the police investigation and for their duties. It can't be just, hey, I wanted to find out what happened about that patient. Just because they're a police officer doesn't mean they're entitled to the information. It's only if it's when they're carrying out their duties. You can share, and you have to share when you're required by law. The one that comes to mind is DCFS. You go and there's a child abuse situation, you have reporting requirements, and you can share with DCFS, or if you have a court order, and we'll talk about subpoenas and all court orders in a minute, but you can share for most court orders, you're allowed to share.
So DCFS comes in and says, I want all the ambulance reports for 428 Green Bay Road.
Mm-hmm.
Do I have to give them to them right there, or do they still have to
No.
go through a process?
I would make them fill out a request.
So even an agency would fill out the report?
Yes. So what I would do, so this is but you have a reporting requirement, correct? If you go to a house and there's a situation where you suspect child abuse,
Right.
You can then share. That's okay. That's absolutely fine. Now that's also, once you have it, that's you telling somebody else, different than a request. And when somebody requests, DCFS comes in and says, hi, I'd like these records. The best thing to do is get them to fill out a request, contact me. So there's a lot of different reasons why we may not be able to give it out. The law is very technical, particularly, it depends on the agency. DCFS, we're more more able to give them records. But I've had situations before where we have, let's say, a state agency who's investigating a workplace injury, or, you know, a Department of Labor issue, and so they want records. We've had requests that all records involving certain incidents because somebody's doing a background check for the federal government or state government. So just because they have a badge or a, you know, a letterhead that says I'm from this agency doesn't mean they automatically get it. So what we need to do sometimes is look at it, scrutinize it, look at the law very carefully. So get them to fill out the request, send me an email or give me a call, and we'll talk it through. Usually we can give it to a lot of other agencies, it just depends. So not all have a right to get it. So let's talk about some situations and put everything kind of that we've just talked about into play, and have some scenarios here for you. And I'd like your thoughts. So the bicyclist is hit by a car, and you're treating the person in the street, and there's other people around you can see and are watching. Is it a HIPAA violation?
Incidental exposure.
Okay, you think incidental exposure? Anybody else? Captain?
No, because I mean, I agree with what you described before as incidental.
Okay.
Because you don't have any control of. I mean, you have control of a very small portion of the scene. You can't help it if there's people around.
Okay.
You know. As long as you're not blurting it out, right?
Right. So I think that the general rule is it depends. So remember, incidental exposure, it has to be an emergency, in your professional judgment, and in the interest of the patient. Or if it's the incidental exposure, remember you have to use reasonable precautions when, you know, treating. So you can't shout it out. So in this situation, it depends. I don't know the exact condition of the patient. It appears they're being backboarded. So obviously, in situations where you need to provide treatment in the street, you do it, and it's okay if people see. If it's an emergency, and that's in the best interest of the patient. Now remember, with HIPAA, I'll say this, you have a HIPAA obligation, but your number one duty is to care of your patient. Do what is best for the patient. Don't worry about HIPAA. We'll deal with HIPAA later. Make sure they're getting the best treatment possible. But let's say the person's completely stable, and you want to have a conversation with them, and it's totally prudent and practical to have the conversation in the ambulance. Wait till you're in the ambulance. It wouldn't be an incidental exposure reasonable if you can do it in the ambulance. Now that's not to say that you should scoop the person up as quickly as you can before stabilizing them, rush them to the ambulance just because you want to talk about medical information. So generally though, the rule is you can share and treat the person there, but just use common sense about it. Something a little more difficult though. You're treating somebody on the street, and they pull out their cell phone and they want to videotape you doing it. Should you let them videotape, or is that a HIPAA violation?
Patient or bystander?
Bystander. Somebody sees you treating the patient.
It depends.
I don't think you can stop them.
Okay.
It's a good answer.
Safe answer.
You don't think you can stop them? Why?
I mean, you see, the police, people are videotaping. They know they're videotaping, and they're not really, unless they're creating an unsafe situation.
Mm-hmm.
I don't know, unless there's a law out there. I don't know that you can stop
Let's
someone
say you're
from doing
treating
that.
that patient, and it's a woman, and in order to treat her, you have to remove her shirt, and so she's exposed on the sidewalk. And this person stands gets real close and just stands there, videotaping the whole thing.
That's different,
You think it's different, okay?
especially if they're,
Because of their state of undress.
well, no, I'm saying regardless of their state of undress,
Okay.
someone coming up to and
Okay.
capturing the intimate discussion between the paramedic and the
Okay.
patient would be a lot different than someone standing a half block away.
So let's say they're right up there, and so let's use three scenarios: half block away, the close but not interfering, and then right up in your face, where you can't work and it's awkward, and I'm standing right here is while you're working, and disturbing you, which is a different situation when they're actually disturbing what you're doing. So if they're disturbing what you're doing, you have every right to say, you need to back up. But let's say they're further away, they're not disturbing your ability to work, but they're really close, they can hear everything, they can capture what you're saying on camera,
I think we can prevent it from doing
okay?
I think that's, yeah, I think you'd be, because now if they're able to capture that information, then it is, I mean, I would think that would be a HIPAA violation. Or,
So this is actually, it's interesting, because I've gotten this question in the last couple of months, I think 4 different times from 4 agencies. We are in a world where everybody has a camera and is videotaping everything, so if it hasn't happened to you yet, it will. Sometimes whether it's a car accident and people are just, or whatever it may be, it's a sensational thing, it's gawking and they want to do it. Other times it might be, the wife, if you're treating the husband, who wants to make sure you don't screw up, and it's a malpractice issue. My general advice is, unless they're right up in your face and interfering with your ability to do the work, you cannot ask them and you cannot tell them they cannot videotape. Now again, if you're using, it's incidental disclosure, you're using reasonable measures to do what you can, to not shout or whatever. Or, it's an emergency, and it's part of the journey, it's just the way it goes. You're protected from HIPAA, and what this person, the third party, the guy who's with the camera, if he happens to hear it, it's not a violation because we've earned an exception, and if he decides to post it on the internet, that's his problem. He's not a medical provider, he's not bound by HIPAA, but that's his problem. He also has a First Amendment right to do this, particularly if it's a public sidewalk or public street or a public restaurant or whatever. He has, if it's in a restaurant, the owner of the restaurant can say, sir, you're gonna have to stop videotaping this. But you, as a public employee, really don't have an option. They have a First Amendment right, and I would not pick the battle. Don't pick the fight. Now, maybe because the person's in a state of undress or whatnot, or just it's gruesome, there's nothing that says you can't have 2 of you stand between you and the person